by criminal defense attorney Ryan Pasiga. Ryan, we all know that opening statements are scheduled for just a few hours and all eyes are on Minneapolis right now. So what can people expect when we hear opening statements?
Well, sometimes the public thinks that opening statements involve argument from the lawyers. Argue their case at this point in the game. So what we can expect is that the lawyers are going to tell a story. They're going to present their version of the facts that they anticipate the juries will see. And what's important there is that a lawyer is trying to get the jury to see the story through the lens that the lawyer believes they need to see it to render a verdict that they want. So you begin with that, building that story during jury selection or that theme. And now you continue on with that theme in opening statements, previewing the facts from the lens that you want the jury to see it from.
Now, Ryan, you mentioned how attorneys are painting this picture, right? But we've heard time and time again that jurors are supposed to leave emotion out of it and make a decision solely on the facts. But that seems somewhat impossible. We all saw the video of Derek Chauvin and George Floyd. How will testimony or even opening statements be used to appeal to emotion? And is that a tactic that prosecutors may use?
Yeah, absolutely. So lawyers aren't prohibited from presenting facts that elicit emotion, of course. But you're right, jurors are, of course, instructed that they are not to decide the case on emotions. That being said, we know that the video that's at the heart of this case is a very emotional video for people to watch. And you can bet that the prosecution knows that that lives within each one of the jurors to a certain degree. And the prosecution is undoubtedly going to tap in to the emotion here. The idea that perhaps a death could have been avoided had different actions been taken, that somebody was lost for what a lot of people will see to be sort of a minimal crime, and that it didn't need to rise to that level of constraint and those sorts of things.
And Ryan,
I think what might be interesting, oh, go ahead.
Oh, I'm sorry, what would you find interesting?
I think what might be interesting is whether or not the defense uses emotion in their opening statement as well. They could go one of two ways. One way to defend this case would be to eliminate as best you can, or to sanitize the emotion in the case and just be very scientific, for lack of a better term, about, hey, this is about reasonable doubt, and let's just get matter of fact about it and sort of apply it as almost a mathematical formula in a way. Or do they take the road of emotion on the other side and try to paint him as an uncontrollable person and an officer that, because of his training that he had at the time, felt like he was stuck to adhere to department protocol and that policing is a tough job, and try to elicit some sympathy from him?
Now, we've seen time and time again Judge Cahill tell jurors to stay off of social media, to avoid major headlines, so that way that they aren't clouded by what's going on in the world, right? And that seems a little bit hard to do. We've also seen the defense try to move the trial out of Hennepin County. Do you think it's possible for Chauvin to get a fair trial with all of these elements?
It's very hard. I mean, when this case first came out, I thought there was no way in the world it was going to stay in Hennepin County. But as I've saw the juror selection process go on and thought about it more, I think Judge Cahill's right in that where in Minnesota would you be able to get a more fair trial? Even though Hennepin County is ground zero for where this case occurred, there's still the element that people from coast to coast know all about this case. And I think you're going to encounter those same issues even if you move it out of Hennepin County with respect to jurors hearing about the case, hearing about the settlement, and all those sorts of things. So I think Judge Cahill did a very good job to screen that out as best he could. And at the end of the day, the lawyers got jurors that are committed to setting aside those undue influences and committing to deciding the case based on the facts that are presented to them in this trial.
Right, and what do we know about the jurors?
Well, we do have a diverse jury.
Okay.
We know that. We know that jurors were honest about having seen the video, for example, having known about the settlement agreement that's been reached, having some internal biases that we all carry into a courtroom. Some people lean a little more favorable to law enforcement. Some people saw the video and said, well, it's troubling me, but I think I can set it aside. So I think what we know about these jurors is that they're committed to being as fair as they can coming into this case. And I think they had every chance in the world to get out of this trial if they wanted to. The fact that they went through all that screening and made those commitments to both lawyers, to the defendant, and to the judge indicates to me that they're in it for the long haul, and I think they're going to do everything they can to give them a fair trial.
So as we keep reminding our viewers, opening statements begin today. Is there anything significant based off your experience that you are maybe looking to hear or see this morning?
Well, I think I want to see how the lawyers can engage with the jury. So you really need to connect with jurors when you're trying a case. There are particular challenges for both of the lawyers in this case, and that is, given the social distancing that needs to occur in the courtroom, the jurors aren't all sat together in a jury box. They're spread around the courtroom, even into the gallery in the courtroom. And the lawyers have to be anchored to the podium in the courtroom. They can't walk up to the jury and move side to side in the courtroom and those sorts of things. So it's a very sort of sanitary presentation that's going to happen today. Makes it much more difficult for both of them to connect with jurors. And I'm interested to see if there are still ways to do it. But this is an opportunity where if the lawyers haven't thought about how to do that, given these constraints, one could come out much farther ahead than the other if they're able to connect and adapt to these constraining circumstances in this courtroom.
Now, Ryan, so you touched on social distancing, but jurors are also wearing masks, right?
Yes, they are.
It seems as though that would present another problem because you can't really see, as lawyers are trying to connect with jurors, how can you tell their reaction if they are agreeing or if they are not liking what the lawyers are saying? Wouldn't that present an additional challenge?
It absolutely can. I mean, we're looking for these things all the time as well. And so you're going to look for things like folded arms, for example. You might see the eyes come off and not connect with the lawyer. Sometimes even with a mask on, you can see things like, you can just see a little bit of a smile, for example, or you might look for those eyebrows, like, really, you're trying to tell me this? So they're going to have to be that much more cued in, but absolutely, you're losing that dynamic of what's going on with a person's facial expressions, and that makes it harder for everybody.
It'll be interesting to see how attorneys connect with all of these challenges. Ryan Pasiga, thank you so much for joining us live from Indianapolis.
Thank you. Take care.
And right here on NewsNOW, we will